Welcome to the AI Cafe today, and our speaker is Jan de Bruyne. He is research expert of tort law and AI and lecturer at Catholic University Leuven Centre for IT and IP Law, in short CiTiP. And he is assistant professor at eLaw Centre for Law and Digital Technologies, Leiden. And with his talk today, who pays the bill when an AI system causes damage? Great, you're all coming in. I see you entering the cafe. Welcome. Here in Cologne, the sun is shining, so it's great you joined anyway. And with us is today Teresa, our co-moderator, Teresa Felschen from Grassroots Arts. Me, Carmen McWilliams, I'm your also co-moderator and organizer from Grassroots Arts. And this cafe is funded by the European Commission and the European Research Project AI for Media. So please take notice that the session will be recorded. No confidential information shall be shared in this cafe session. In this cafe, the speakers express their personal opinion. It is not necessarily the official AI for Media opinion. So, and what's the cafe about? The cafe is an online forum to gain insights into the European AI scene. So, most important, our speaker, Jan de Bruyne, and I. Hi, Jan. First, hi. Can I hear you? Hi.
Hello. Good everyone. Hello. The sun is shining in Belgium as well, so everything is perfect already.
Yes, great. Yes, and I will now introduce you to the audience. Dr. Jan de Bruyne obtained a master's degree in political science at the University of Ghent in 2008 and a master's degree in law 2012 at the same university. He has been an assistant in comparative and private law at the Ghent University Faculty of Law and Criminology since October 2012. He successfully defended his PhD in September 2018 on a topic dealing with the liability of third-party certifiers. His PhD was published by KU Law International. During his research, he became interested in liability for damage caused by AI systems. Jan de Bruyne was a postdoctoral researcher at the Ghent University Faculty of Law and Criminology, working on robots and tort law from October 2018 to October 2020. And then he started working at CiTiP in October 2019 as a postdoctoral researcher on legal aspects of AI and as a senior researcher within the Flemish Knowledge Centre for Data and Society. As from November 2020, he works at CiTiP as a research expert on tort law and AI. He's still associated with the KDS. He has recently been appointed as an assistant professor in law and digital technologies at the eLaw Centre for Law and Digital Technologies in Leiden. So congratulations. So you are now an assistant professor, so great. Yes, and now I see the audience is there. Thank you again for everybody out there coming today. I will now hand over the moderation to Jan. He will introduce his talk and we are looking forward to your presentation. It's you.
Yes. Good afternoon again. And normally you should see my slides, right?
Yes, we see it. Perfect.
All right, you see it and you hear it. That is fantastic news. So if there are during the talk some technical issues, feel free to interrupt me and keep your questions and all remarks, critical remarks, also until the end of this presentation, or drop them somewhere in the chat. A disclaimer already, I will probably not be able to answer all the questions, but yes, that is what it is. But the nice thing is to have some debate. Now, I will not introduce myself because this has already been done, but I will introduce my talk. And when we talk about who pays the bill when AI causes damage, I will focus on questions of liability. who is responsible when things go wrong in the AI chain. And of course, this is to a large extent, or a very large extent, determined by contract law, because the contracts may also deal with the allocation of risks. But what I will focus on is on extra contractual liability, on tort liability, on product liability, on the operator's liability. So I will focus on these kind of actors. Now, why is it necessary and why is it such an interesting topic? Is because accidents do happen. I refer to the self-driving car, that accident with Joshua Brown in the United States, but also robotics in surgery that cause damage, other AI systems that potentially discriminate but also cause damage. And I reckon that AI-related damage will increase. And this is, of course, unfortunately, not always a good thing, but for tort scholars, for legal liability scholars, it is, of course, a nice thing that we will have case law, that we will have incidents, that we will be informed on how liability can be used as a mechanism to increase trust in AI systems, how it can be used to allocate responsibility. Because as I will show, determining which party is liable, so who pays the bill in the end, is not straightforward. It is very challenging, and this is what I will do. I will first set you a brief overview of liability and artificial intelligence. I will set the scene on liability because we talk about liability, but it is a multi-phase concept, let's say. There are several kinds of liabilities, so this is what I will first do. I will then, more interesting, focus on some general challenges in tort liability and AI. So what are the most challenging elements, the most difficulties when you are confronted with claims in which AI caused or was related to damage? I will then also show quite obviously that the more autonomy systems have, so if they have more autonomy, of course, the liability of the users will be less easy to determine. I will then briefly go towards alternative liability regimes, and especially product liability, which is to a large extent harmonized, but also given a lot of attention in scholarship. And I will then end with some few recommendations and key takeaways during the talk. But I hope that the other points will already make my views, which are very personal again, clear on this topic. First things first, setting the scene on liability. One should know that we have civil liability and criminal liability. Now, my research focuses on civil liability, and there's a whole distinction between, for example, the burden of proof between criminal law cases and civil law cases. There's also difference in who can prosecute between civil liability and criminal liability. Also, crime is more related to those offenses that society considers really important, whereas civil liability could also incur when you have a contract or when you, for example, incur civil liability damage without being something that the state considers to be fundamental, for example. My focus is on civil liability, and within civil liability, one has to make a distinction between contract law and tort law. Contract law, as I mentioned, relates to the allocation of liabilities in the contractual setting. And this, of course, is obvious and important in this AI digital supply chain, in which parties constantly allocate or disclaim liability between themselves. And so this is a contract, so it is a liability based on the contract. If the contract is not performed, there can be the liability of one party. But the most important requirement there is the fact of have a contract. More interestingly, and of course this is because I'm a tort law scholar, but also because the role of humans, I reckon, is still very important in tort law, relates to the situation in which you do not have a contract. For example, if a pedestrian that crosses the street gets hit by a self-driving vehicle, well, this pedestrian does of course not have a contract with the producer of the vehicle, does not have a contract with the AI developer or with the driver. So these kind of claims are what we call tort or extra contractual liability. There is no contract. This is important to know because I will focus on the requirement of tort law, and again because it has been given a lot of attention in academic scholarship, and more importantly, in recent European Union documents. We've set the scene, very quite legalese maybe, so this is why I will not go too deep into it, because it can be maybe boring, but know that we focus on this extra contractual liability for the remaining parts of my presentation. Now, we come now to some general challenges of tort liability and AI. General challenges that occur when you have this extra contractual liability. So for example, if you're a pedestrian, you got hit by a self-driving vehicle and you want to claim compensation from the operator, for example, or the producer. A first big challenge, and this is really important to know because it affects my vision and my view on what the EU should do and should not do, is that as opposed to, for example, the GDPR, as opposed to, for example, consumer protection, tort liability, so liability law as such, is still very national. It is very much dependent upon the member states' framework on liability. This can be, of course, challenging in an AI context that is actually transnational, which crosses borders. So this is already a first challenge we should take into account, that when we talk about liability, when we want to regulate liability, well, one should be aware that in most cases, product liability excluded, but I will discuss this later, but in most cases, fault-based liability or other forms of liability, it is still very much national. So national law will be of fundamental importance when we talk about tort liability and of AI systems. Despite this reality of the importance of national law, which we have to consider, there's been several documents that have been issued by the European Commission on liability. And I will not, no worries, I will not discuss all of them because, yeah, it would be really boring, let's say. But liability, product liability, fault-based liability has been given prominent attention in all these EU documents. There's been even a consultation on liability, which I see that it's ongoing, but of course it's already finished in January 2022. So things are moving at the EU level with regard to initiatives and proposals on liability, which of course we welcome. I welcome this, that policymakers at the EU level think about these fundamental issues when it comes to liability and who has to pay when things may go wrong. The problem is, and this is what I link with my previous question, is that even if you would have European frameworks, even if you would have supranational views and proposals on liability, national law remains fundamental. And I took the example of this proposal for a regime for the operator's liability that has been included in the resolution of the European Parliament of October 2020. So the idea, and I will discuss this later, is that operators of AI systems can be held liable. Now, if you would look at the wording used in these provisions, so for this EU regime, if you look at the wordings that are used in these provisions, for example, I will not read it, but look at the questions of causality, when is damage caused by an AI system? What is meant with reasonable and necessary measures? How to apply and interpret due diligence? Well, this has to be determined by national law. So you already see a challenge that even if you would adopt a framework at the EU level, national judges will eventually interpret, apply, and determine the content of these fundamental elements. For example, force majeure as well, due diligence, causality. And this may result in differing approaches between member states. So when we talk about tort liability and AI, it is more than just liability. It is more than just this purely technical element. It raises fundamental question of how to make sure that we have a similar approach for all member states, taking into account that tort liability is still very much national and hence different. My first thought, and I'm happy to hear some reactions on that, how can we harmonize this? And as I mentioned, I will not have all answers, but I will have some elements that could be used as a way forward. Again, here, I think interdisciplinarity And multidisciplinarity cooperations between researchers of all member states is, of course, a way forward, but I will come to that later in this presentation. As I mentioned, tort law is very much national. AI is what I call transnational. That being said, we have several liability regimes in which to be honest, I think proposing this at the EU level may create more problems, interpretation of concepts, than it will actually resolve problems. That being said, I very much welcome the regulation on AI, which has been issued last year. And as you know, it contains a risk-based approach, which means that some AI systems are prohibited. For example, those used for social scoring. Other AI systems are qualified as high risk. There's a definition of high risk in the proposal, and also the attachment contains a list of several standalone high-risk AI systems. For example, AI used in recruitment or medical devices, or other for justice. There are also certain high-risk AI systems. These kind of systems have to comply with additional obligations. There's also AI with specific transparency obligations. For example, deepfakes will have to be mentioned that these are deepfakes. And finally, you have AI systems with minimal or no risk, and these are permitted under no restrictions. Very good thing. I reckon, especially also for liability, this proposal, it does contain several clear obligations for the provider of AI systems, for the user of AI systems, which I very much welcome in an AI context, because we need to know, of course, what can be expected from parties? What can we expect of users of AI systems? What are the standards, the requirements that developers have to comply with? So this solution, this regulation, is a step forward. That is risk-based approach. It is now under review, in discussion at the Council and at the European Parliament, and there will be this ping pong between all these institutions, and a lot of amendments are already made. So this is something that we need to follow up. First challenge, regulation, tort liability national. The EU taking supranational initiatives, which works, but for liability it will be challenging. And one can ask, do we really need a new liability of operators, which is seemingly the way forward, the way that the EU is taking? Do we really need a regime, a new regime for operators at the EU level? Don't we need more targeted approaches, interpreting, applying certain problematic concepts, or looking at national alternatives? How do we also harmonize it? First challenge. Second challenge when we talk about tort liability is, in all these tort claims, liability claims, it is up to the victim, in most cases, that has to show and prove several elements. For example, the victim will have to show that the AI provider committed a fault. And the victim has to show where things go wrong in the AI supply chain. The victim also has to show what we call a defect in the AI system under the product liability regime, which I will discuss in some minutes. The victim also has to show that the AI system actually caused the damage. So this victim, this pedestrian, for example, that got hit by the self-driving vehicle, leaving aside insurance matters, of course, but the idea is that this victim has to show the fault of someone in the supply chain, has to show that the AI system that was defective, which is already challenging, caused, is the reason for the damage to occur. So this is actually very challenging, and also I think impossible, because AI, you know, it works as a black box. It's not always transparent, so we do not always know where things may have gone wrong. Especially if you are not an expert, if you have the lack of expertise on AI systems, well, it can be even more problematic and challenging. So I ask you, suppose you would incur damage involving an AI system, you'll have to prove where it go wrong. And I think that is really challenging and almost impossible to do. Also, there are many actors involved in this AI supply chain. You have the operator, you have developers of AI, you have the producer, you have the users, you have potentially also states or governments that are involved in liability claims. For example, in self-driving vehicles that may not work properly because of lack of connection with public infrastructure, for example. So you have so many actors, data developers, data suppliers in this chain, that it makes it difficult to find the one liable person. Again, a big challenge when we talk about liability claims. And as I mentioned, AI systems can be self-learning, so the defective problem may occur anywhere in this AI supply chain. So in addition to the difficulties of the level in which we operate at the EU level versus the importance of national law when it comes to tort liability, we also have this huge burden of proof, which is, I think, impossible to do. And I'm not the only one who thinks that. This is identified in all these documents that I listed in one of the previous slides. These studies, these proposals by the European Commission. For example, the idea is to reverse the burden of proof, which would then mean that the AI developer has to show that he or she developed the AI system carefully, for example. So no longer the victim has to prove that something went wrong, but the provider has to show that nothing went wrong. So you put the burden of proof on the party with the most expertise. Other things is strict liability, in which you actually say, well, the moment an AI system causes damage, it is the operator that is liable regardless of fault. Strict liability. Fault is no longer required. Another more contested option is legal personality. In this situation, you say, well, you give the AI system, so the self-driving vehicle, for example, you give it legal personality and you can hold it liable itself. I know this sounds very hypothetical, but the idea of granting legal personality to non-humans already applies for companies, for example, for states that can also be held liable. So this proposal to grant legal personality to sophisticated robots has been made by the European Parliament in 2017. It has been rejected afterwards by almost everyone else. But giving this legal personality to, for example, an AI system would really help this burden of proof, because you do no longer have to show where things went wrong, that something caused the damage. No, you could just say, well, the car caused the damage, it is liable. Something to think about. I'm not saying I'm in favor, I'm just saying that we need to think about, if we would ever do that, which legal personality do we give AI systems? Legal personality is something different than ethical concerns, for example. So an alternative for the general burden, the high burden of proof that victims may face. We've seen, I hope that you're still following. We have seen several elements already. We've seen the general challenges. We've seen the difference between the different kind of regimes. Let me now go to my third point by showing to you that the more autonomous systems become, the more difficult it is to impose liability upon the user. And of course, I give you some visuals there. But I think self-driving vehicles, they used to be much promising. It turned out that we may have expected too much of self-driving vehicles, but it's still an area which also led to accidents, making it interesting to analyze it from a liability perspective. Now we are in different levels of autonomy, and we are currently in level 2 or 3, vehicle autonomy. In those kind of vehicles, the driver still has to supervise the system. The driver has to intervene. So still, humans are still required, and hence liability becomes very interesting. We are at level 2 and 3 vehicles these days. So the idea of self-driving, the notion self-driving or autonomous, is actually a bit misleading. And there have been claims in the United States for that reason, saying, yes, but this is misleading information, because you as a driver, you still have to supervise the system. And this is important from a liability perspective. I will show it to you with this figure. In level 0 to 1 vehicles, the ones that are nowadays still very much on the road, well, it is a driver that has full control and it has to take over whenever necessary. The driver remains in control and hence can be held liable. That is not really a problem. In the third category, so in the far, far future, if we would ever get there, the full driving vehicles are allowed on the road, and you can actually, as a user, you can indeed read, you can sit, you can watch telly, work, and you do not have to supervise, you do not have to control the vehicle. In that category, of course, liability is not challenging either, because you, as a human, you have no control on it, so you cannot be held liable, obviously. You're just what we would call nowadays a passenger. This is another category. So in the first and the third category, no, from a liability of the users, no real challenge. More challenging is, of course, the category we are currently in, namely the ones in which the vehicle takes the initial decision. For example, the vehicle drives or turns to the right or left or makes own decisions, and you as a human user have to supervise it. You have to supervise the system and interfere, take over whenever necessary. So there's this kind of interaction between the machine and the vehicle or another AI system and you as a human that still needs to have human oversight, control, and you need to take over whenever necessary or whenever the system gives you the signal to do that. Well, in that category in which we currently are, many legal challenges will and are already arising. And I will not go too much into technical details, legal details, because again, it can be very challenging, legal difficult. But I will just show to you that in the second category, in which the vehicle takes the initial decision, and you as a supervisor, human supervisor, have to supervise the system. As a human user, have to intervene whenever necessary. This creates several challenges. First of all, who's the driver? The driver is the person that has all these obligations. For example, the driver may not cross a red light. The driver has to give priority to the right. The driver has to slow down. So all these requirements are for the driver. The first legal challenge, which leads to a lot of debate, is, okay, but up until when moment does the driver stop being a driver? Legally unclear. More importantly, it is the vehicle that takes certain decisions. For example, it is the vehicle that crosses a red light. You as a human, you just fail to prevent it from happening. So you do not prevent it. You do not intervene when you're required to. But the initial violation, the initial crossing of the red light is done by the vehicle. So the question then arises, can you actually attribute the act of the vehicle, namely crossing the red light, can you attribute it to the human user who did not commit that violation? This can be far going because you would be blamed by something that you have not done. Again, legal difficulties. And of course, if you look at court law, case law, that is already existing, for example, in the Netherlands, where this exact situation was filed, where it was said that I think the driver was fined because of looking at his phone behind the steering wheel, and he claimed, yeah, but I'm not the driver. It clearly is the AI system, the car itself. The judge did eventually not follow it because you as a driver remain responsible, but another decision may well have been taken. But it's far going and legally unclear. Also, the negligence of the user, for example, when can you say that you act negligently? If the more autonomy is in the system, well, the less, the more inclined you'll be to just relax and do something else. So when is someone negligent? When does someone not act as a reasonable, prudent person, for example? Short, you can go very far in this legal analysis, in these legal challenges, but in the second category, it becomes clear that legal challenges do arise. that there's still much unclarity. And it is the category that is the most important. So the coming years, there will be a lot of case law, a lot of more clarity on these kind of legal issues. One thing for sure is that the more autonomy an AI system will get, the more autonomous a car will become, or any other AI system, for example, being it a robot used for surgery, the more autonomy it will get, the more important other regimes will become, and because the human fault becomes less important. Think of category 3 of the self-driving vehicle, in which the human user no longer has control and cannot be held liable. So eventually, you'll need to go to other regimes. And it is in this regard that the product liability regime is very important, because this is an EU proposal stemming from the 80s, actually. So it applies to different member states. Of course, it gives freedom to member states still, so no full harmonization. But it's the regime that is getting a lot of attention and that has attracted a lot of debate, and all these proposals that have been made would center around this regime. Under this regime, the producer is liable for damage caused by a defective product. This is what, remember, the strict liability. The producer is liable for damage caused by a defective product. So you need 3 elements: the product that is defective, for which a producer is liable when it is put into circulation. Remember this, it may seem as an easy rule, the producer is liable for damage caused by a defective product. Quite obviously, if I buy a chair and I come home and I sit on it and it breaks, then you could say, well, the producer is liable for damage. For the damage, the product is defective, so the producer should be liable. This is the starting point, which is for physical good, tangible goods, quite obvious. Now, our first challenge is, do you consider software is an algorithm? Is it a product? Because if it's not a product, but a service, for example, then it's excluded from this consumer-friendly rule, consumer-friendly liability rule. So is a software, is an algorithm, is it a product? Much debate, still unclear. This is still unclear. Also between the European Parliament and the European Commission, there seems to be some differences. The Product Liability Directive defines a product as all movables plus electricity. So it refers to all movables plus electricity. The question is software a movable? Unclear. Of course, if your software is integrated in the car, then of course it is seen as part of the car, as a vehicle, which of course is a movable item. So you could look at the car itself, integrating the software, which is then a movable. But pure software alone, which of course is important, because you could say that the software producer is what we call the cheapest cost avoider. Pure software, the question remains, is it a product? Is it a movable? Is it tangible or not? This is not required, but it is required in Belgian law, for example. Belgian law defines a product as all tangible, movable items. So the question is software tangible or not? Some say, no, it is intangible. It cannot be seen with the eye, for example. Others say, no, well, it only applies to movables. That is exactly the reason why electricity was included, because it applies to tangible goods, chairs, footballs, and electricity, but not to software. And I think, and this is again my personal opinion, I think that there is actually no legal reason why software should not be included in this product liability directive. It stems from the 80s, and of course back then software and personal laptop, personal PCs and all these technology was not as prominent and important as it is nowadays. So of course in the 80s we could not foresee the importance of it. But the fact that electricity was included in this framework is clearly showing that it's a very broad scope of application. So I think that there are certainly some reasons to include software in this regime and to qualify it as a product, at least from a legal perspective. Of course, this is important for the initial question, who pays the bill when an AI system causes damage? But if you consider pure software, standalone software as a service, well, then it's not included in this regime, making it more difficult. The second element is you do not only need to have a product that causes damage because of a defect, but you also, in addition to this qualification of product, it also needs to be a defective product. A product, and I say it a bit easier, that is not working as it is supposed to work, that is fault, let's say. And I know it does not make sense from a legal perspective, but to clarify, it means that an AI system is just not working, causing damage because it does not work as expected. Now, this notion of defectiveness is defined as the safety that one is entitled to expect. So a product is defective when it does not provide the safety that the person is entitled to expect. The so-called legitimate expectations, legitimate safety expectations. It's important to know, of course. What level of safety can we expect from AI systems? Can we expect absolute safety? Can we expect almost absolute safety? So what are the legitimate expectations we may have from AI systems? And I think this is not only a legal element, but also policy-related decisions, societal decisions. What can we expect from AI systems? Also, one of the elements that we can take into account is the presentation of the product. And there what you saw is that, of course, if you keep on presenting your product as being very safe, for example, take the self-driving vehicles, in which the safety component is emphasized a lot. It would create less traffic accidents. It will increase safety, more road safety. More autonomy in traffic creates to more safety in general, more road traffic safety. But by emphasizing the importance and the increase of safety, you also increase the legitimate expectations and also the risk of liability. Because when you use a self-driving car, you would almost expect absolute safety. If it would then cause damage, well, then you could say, well, this is not what I expected. So in an AI context, in addition to this qualification of product as being software, yes or no, another difficulty, which is still unclear, is the notion of the effect of AI systems. What are the legitimate safety expectations of an AI system? And I reckon that there's not one answer for this. And again, I think the need of interdisciplinarity, the need to work together with social scholars, legal scholars, engineers, AI developers, to really concretize, make these terms concrete. Finally, the last point of product liability, and then I'm almost at the end of my presentation, leaving sufficient time for some Q&A. A producer is liable for damage caused by a defect in the product. But of course, the producer is not liable when the defect causing the damage did not exist at the time when the product was put into circulation, which is quite obvious due to, for example, usage. A producer of a chair may not be held liable for defects that are caused by this chair after 10 years, for example. So the producer is not liable for defects that came into existence after the moment the product was put into circulation. So you look at this moment at when the product is put into circulation. Well, this is again problematic for AI, because when could you consider that it is put into circulation with the self-learning nature? AI systems are self-learning. So when is it put into circulation? What with the software update, for example? Could this be qualified as a new moment of putting the AI system into circulation? But again, legally very difficult. So you've seen, the more you evolve towards, the more autonomy for AI systems, the less liability for users, the need for alternatives. But again, the difficulties, of course, in applying the product liability directive. Is software a product? When is an AI system defective? And what about the defenses for the producer? That is why we increasingly see, and I already mentioned it on one of the first slides, is that we have at the EU level an upcoming ideas, a resolution, but I think it will be the way forward, and it's my own view, of course, that we will go towards the liability of the operator of the AI system, and the person that creates risks, but it also enjoys, for example, the benefits of AI systems that put others at risk. And then again, the difference is made between back-end and front-end operator. I will not go into detail, but this concept of operator, so it's not a producer, it is the party, for example, responsible for back-end services, the party that decides to use the AI system, creating the risks, we will move towards a regime for operators. And again, the idea is there to make a distinction between strict liability for the operator of a higher risk AI system, and strict liability, no need to prove a fault. The mere fact that an AI system causes damage will be enough. And fault-based liability for the reversal of the burden of proof. Again, the question is it desirable? Is it the way forward to have another regime at the EU level, creating potentially more problems, more interpretation problems, as I mentioned, that national alternatives will remain very important as well, and national judges will eventually have to apply all these concepts. So we have seen liability, a very challenging topic, different views on it. We have seen some general challenges for AI and liability and the high burden of proof, which I think is one of the most important ones. Tort liability goes hand in hand with procedural elements. We need to think about reversing the burden of proof. We have seen fault-based liability, which becomes challenging, which is now challenging in this interaction between AI systems and humans, which will become less relevant the more autonomous AI systems will become. But we have also seen that existing alternatives, product liability, operators liability, also creates legal challenges. So I reckon that for legal scholars, I think it's very interesting times, very important times to really, we're sure to have work, let's say, because problems will arise, linguistic, legal problems and challenges will arise. My final key takeaways is, and I think it is by now very clear, the fundamental questions that we have is, do we need a new framework? And I think we don't. This is my personal approach, my personal view. I don't think we need a whole new framework for AI liability. I think that existing regimes surely have their benefits, but we need some targeted specific approaches. We need some modifications. And to that end, we should focus on concepts. For example, questions of, is software a product? Still unclear. When is an AI system defective? By bringing these kind of clarifications, I think this would be a great added value. And this is what we do with the Knowledge Center. We use policy prototyping for, this is a new method of policy making, let's say, where we involve really stakeholders, where we organize surveys. And I think these kind of methods can also be used to concretize these concepts of, for example, defectiveness, fault in an interdisciplinary context, and where you work together with all disciplines to really make sure what is understood under these kind of terms. Eventually, focus should also be on judges, I think, because they will have to apply and interpret these concepts. I refer to the Tesla case in the Netherlands, but more cases will follow. So we need to make sure that judges are also involved in the digital AI evolution. And I think the most important thing is data literacy in general, because the law and I reckon the ethical frameworks will eventually adapt themselves, especially the legal framework. Civil liability has adapted itself already for such a long time. The former Belgian Civil Code already exists so long, has survived so many evolutions. I'm quite sure it will also, with some targeted approaches, survive AI as well. But we need to make sure that data literacy of citizens, of people, making sure that everyone is involved, has the digital skills in this digital world. This was my brief talk on tort liability. I hope you found it interesting, and I very much look forward to all the questions if I can answer them. I would say the final conclusion is many challenges, and unclear who eventually still needs to pay the bill, as many parties can be involved. So thank you very much for your attention.
Thank you very much, Jan. That was very deep insight in tort law. For me, who's not a tort law specialist, but I take from I have the first question, then Teresa, and then we go directly to the audience. So I do see who is liable, and I understand that there is a problem. Is it the human developer, the producer, or is it the operator of the AI tool, or is it actually the victim? So I'm not a legal person, so I'm trying to say it. The question is open, and of course, what I understand is that in the moment we don't have anything which is autonomous. I mean, we do have no autonomous car. We have an operator in the car operating the car. So in this case, the operator is liable, right? That's what you. And my question is, this is my main question. There must be, is there already an attempt for Europe and for maybe the world, but let's start with Europe, that there will be tort law for all the European countries? Is there already an attempt that you try to figure this out?
Well, because of course AI liability questions has to be seen indeed in this liability bigger framework. The tradition is that in the past, several attempts have been made to come with a unified tort law. And some soft law exists, the principles of European contract law. Okay, this is contract law, but this is soft law. The idea was also launched to have a European civil code, but these initiatives did not make it. So up until now, tort liability and several aspects of contract law, for example, the validity, interpretation of contract law, is still very national. And I reckon that this is, I think, one of the most attempts have been made in the past, but were not successful. So I think if you want to resolve AI systems and questions of liability, you'll have to take the bigger pictures and look at evolutions in tort law as well, and trying to make that first harmonized. But in the past, it did not. It did not work.
Yeah, it's very necessary, I think. Teresa, you have a question.
Yes, I have a question. So the talk was about liability, and I was just wondering if, in your opinion, that the one who's liable is also the one who has to pay the bill automatically. For example, if I drive in my autonomous car and that car causes an accident, does, I don't know, Tesla, for example, has to pay the bill for reparations, for example, but I can also be legally prosecuted because it is my job to pay attention if something goes wrong. Yeah, I was just wondering if those two, come in hand.
Yeah. And as I mentioned in the beginning of my presentation, of course, many of these things are covered by insurances, right? So the insurer will come in between and will cover this to a certain extent. But eventually, the question before is, insuring is about finding and insuring risks, but you need to find where the risk lie. So this is the first thing I want to say. I look at it from a legal, technical perspective, but most cases will be covered by insurances, right? But you're very right, and this is what happens. People often think, non-legal scholars or non-legal people, let's say, they think that there's always one party liable, but this, of course, is not the case. You can have many parties that are liable, also to a certain amount liable. So it could well be in your case that you, as a victim, as a pedestrian, for example, you can file a claim against the producer of the vehicle or the developer of the AI system by saying, yeah, you did not do your job properly, for example. But still remember of the high burden of proof, you'll have to show it, which is, I think, really difficult. But you could also say to the users, yeah, but the user in the car did not pay attention to the road because he or she was working on the phone. So there's also this possibility to have multiple liability parties in addition to all these contractual schemes as well. So your question is right. There's not one party that can be liable, but the user in the vehicle may also be negligent. And this is what happens in the United States with where a cyclist was killed. It was claims were filed against, I think it was Tesla or Uber, but also the person sitting in the car, despite getting many signals of the system, just started looking on the phone, continued looking on the phone, where clearly this is a matter of negligence as well. So it's about different parties, let's say.
Yes. So now, Jill from the audience, how can casual victims, it's similar, casual victims like citizens not knowledgeable in AI could be even aware that the damage came from AI?
Yeah, this is actually bringing me to the last point of my presentation, more general one. I think data literacy is like really the starting point. This morning I spoke at the school, at just like secondary school, but there it starts, right? Like, what can we expect of AI systems and what can we not expect from AI systems? So in addition to digital skills, it's also about like, what is AI? How does it work? What can we expect? And especially what is it not? So I think it's the right question. Again, on the broader perspective, that this question of tort liability frames within the general framework of data literacy, but very valid point there.
Yes. I'm reading another one, and maybe Teresa. Marcus says, a Gartner consultant has raised the possibility that an AI system may reject a certain task if not properly trained by comparing the current task with the training data. For example, an autonomous car that refuses to drive autonomously when it is foggy and icy, at the same time requesting to be driven manually. So the question, what do you think about limiting AI in such a way?
Well, I think that is actually I think this is the way forward, right? Under this AI Act proposal, as I mentioned, there are obligations for providers of AI systems, and one of them is to make sure that your AI system is properly trained in conformity with the necessary conformity assessment, technical documentations. But I think this is the right way. Humans determining what an AI system should do and should not do when it should stop functioning. And I think this is a matter of a measure of reasonableness to make sure that the ones developing AI act reasonably to prevent claims. And if then there will still be an accident, then you could look at the user who ignored this. So I think this is a very good, a good suggestion. And I would ask Marcus if he, my contact details are there for anyone. Feel free to contact me with other thoughts and questions, and especially because I understood that he referred to a scholar. Feel free to send me the name, because that would always be interesting. So Marcus and anyone else, find my email address there and send me maybe the source you have for that.
Yes, Teresa, you want to ask a question?
Yeah, we have one from Zara. In case we give legal personality to the AI systems, what would be the next step if the AI system makes a mistake?
Well, the next step would be that if you give legal personality to an AI system, the idea is that you've seen in this, there's so many actors which could potentially lead to a lack of the accountability gap, that you cannot find someone who will eventually be held liable. The idea to have legal personality for the AI system, for example, for the car, is that you could say, well, the car clearly caused the damage, is involved in the accident, it should be held liable. I know this sounds very stretchy, let's say, but the idea is then that this car, this AI system has legal personality and could eventually compensate the victim, for example, by giving it a fund or so, as is being done with companies, states, for example. So this is a potential solution. But as mentioned, it's not there yet, and I don't think that legal personality will, in the next coming years will come, because it has been rejected so much. So I don't think it will be a viable option.
Okay. Another question by Joanne. Thank you very much. Do you see a risk that producers of AI will contractualize their products as having restricted purposes or uses so they can escape liability? One could imagine that a product is sold as doing X, but can also do Y.
Yeah, well, this is related to the question of, first of all, management of the risks, which is also very important in the AI context. And what can we expect? But I see also the link with these legitimate safety expectations. And one of these elements is indeed the description of the product, but it is indeed one element that that by saying what an AI system cannot do, you disclaim your liability. But I think this already happens for other products as well, right? You have, when you buy a product, you see huge disclaimers. But I think it is not because you have this disclaimer that you cannot be held liable. Eventually, it's all about, yeah, the risk and the proving the fault, proving the defect, and so on. So I see where she wants to go, but I think it does not imply that you cannot be held liable. Let's say.
Teresa, another one.
Yeah, we have another one from Gillis. I hope I pronounced your name correctly. Is there an alternative to a risk-based approach, such as the one in the EU AI Act?
An alternative to a risk-based approach. You mean, well, I would say that a lot of legislation is based on risk, right? The GDPR is also starting from what creates risks. So I do think that the risk-based approach is the right way to go, with certain prohibited AI systems, with certain high-risk AI systems. I think the alternative would just be allowing maybe more of it. No, I'm not aware of any alternative. So I reckon that my question is here. I don't have a clear answer.
Okay, then 4 minutes more. Paul, there may also be situations where there is an operator fault and product liability. This will cause problems when questions of appointment of liability arise. Increase litigation costs and difficulties when under different legal regimes address liability.
Yeah, this is what I mentioned, different regimes. And this is a call for this legal personality for an AI system would be a solution for that, because there would be no coordination problems. There would be no different parties. You just have one party.
Yeah. And Andreas, thank you much for the nice talk. You have mainly talked about European law, and you have shown that this is already quite involved. Can you also say something about how liability is handled in other cultures, for example, in the US or in China? Well, we have only a few minutes.
Well, I think as law is so national, I cannot say something about Chinese law. So I will be very honest. As to product liability, we have this legitimate expectations test, consumer expectations. What can we expect? But in some states of the United States, they do have another concept, another meaning of a defective product. This is called the so-called risk utility approach, where you more look at the perspective of the manufacturer and whether he or she took all measures to reduce the risk, risk utility. So you have several other views on it, but I reckon that this is a major challenge, that every system has its own legal traditions, its own legal concept, and also do not forget the power of contracting law, because you can exclude, you can disclaim liability, and so on. But it already shows that making law at the EU, at the international level, I think is really difficult. It's like, especially for tort law, I think it's impossible.
Yes. Okay, now we are coming to the end, and I know that there are many, many, many more questions, and that means look at this email from Jan.
Yeah.
And send it
just
to Jan.
Reach out to me.
Yes, because we always stop at 4, and that's why. And secondly, the recording, just some people ask for the recording. This will be in the hands of Jan when he says, yes, green light, no problem. He gives me an email, he sends me an email, and then we will publish it on the normal AI Cafe video channel. And presentations, maybe also write directly to Jan. If you want to have a presentation, then he might give it to you.
Exactly.
So yes, and I think this is super interesting. I mean, I see there were a lot of participants here, a lot of questions. So please come back to the next cafe. And thank you, Jan. If you want to have a next speaker cafe, just apply for the fall.
The next one? Excuse me, the next?
You can come back. You are so welcome. You can come back in the fall. If you have something new to tell us, you are welcome.
I may have something even more interesting, because liability, as you may have seen by now, is sometimes really boring as well. But I may have something more interesting. Policy prototyping, which we do, is an exercise with the Knowledge Center in which we really develop surveys, in which we involve stakeholders to really make sure that AI policy, the AI regulation works. For example, now we have with the prohibited practices and the high risk practices, we have developed surveys which companies can use to see whether the system is forbidden or high risk. So I think this is something really promising, and I would gladly come back when we have more of these results to present it and to really ensure cooperation. So yes.
I think that's great because it sounds very practical, so companies might
it
apply
is
it.
Yeah, and it will
Yes.
it will be in English, so I can come and share some ideas.
Okay, good. So we are looking forward. Hopefully, just send me an email when you're ready. So I have to tell you, it's over for today, and thank you very much, and have a nice day, a nice afternoon, and see you soon again. Bye-bye.
Bye-bye. Thank you. Bye all.
Bye-bye.
Bye.